The investor, they will be able to bring their dependents, and the dependents will include spouses and children under 21 who are also single. They cannot be married, otherwise they're not considered children anymore. There are two ways of obviously doing this. There's the adjustment of status process and the consular. Now, a major concern is obviously age out. So if you are investing and you have a child that is already 21, unfortunately they cannot be included, but or is close to turning 21, it's very important that you calculate the times very carefully. Ideally, if the family's in the US and applies for adjustment of status, as long as the child is under 21, they don't have to be concerned about when the EB-5 is approved or when the green card is approved. As long as they file before they turn 21, they will be included no matter how long it takes for the process to conclude. Now, in the event of consular, it's a little different. There's a concept, which is the Child Protection Act. And this act will essentially, the time that it's, as long as you file your immigrant petition, in this case, EB-5, prior to your child turning 21, what the government will do is they will calculate the amount of time that it would take for this EB-5 to be approved. That period of time will be subtracted from the age of the child, so that once they go to the consulate, they are able to still adjust. Now, of course, excuse me, not adjust, they'll still be able to apply and obtain their green card through the consulate. Now, it's important timing in this case, because although you know, the clock stops while the EB-5 is pending, once EB-5 is approved and a visa is available, the clock starts ticking again. So the investor has to be wary of this. The attorney has to be on top of this as well, because if there is a delay in the consular, there could still be a risk. Now, this is mostly a bigger concern for countries that have retrogression, not so much for countries that don't. And retrogression is only, you know, today for a handful of countries in Asia. There is no retrogression in any Latin American countries, and to be, you know, very honest, not likely to happen anytime in the near future. So it's not so much an issue for Latin American investors, but you do have to monitor it carefully. And for those people who have children that are close to being 21, that is certainly a factor that may that may accelerate their decision to pursue EB-5. Now, sometimes I have clients that say, look, I'm not ready to move to the US, and I do plan to move to the US, but I'm not ready just yet for, you know, fiscal reasons, professional reasons. Something that we've seen over the course of the past 6-7 years is sometimes the child can be an investor. So USCIS accepts investors that are 16 years or above. So in this case, a father or mother, they could gift their child the money to make the investment. The investment would then be made in the name of the child. The child could come for university, for example, to the United States. The family or the parents would remain in whatever country they live and finish what they need to do. Eventually, when the child gets their green card, and then with 5 years of green card, or at least when they remove their conditional residence, they can then become US citizens. And as US citizens, they can bring their father under an immediate relative visa, which is very fast and very cheap to do. And I have many people who choose to do it that way, because instead of them delaying this process for the family, it allows them to make their investment. It allows them to have their child come to the US and begin living in the US and studying in the US and working in the US. But they still are not giving up that ability to have their child bring them in the future. So I think that's something that we've seen a greater demand for.